Greg Woods teaches criminology, criminal justice, and legal studies courses at San Jose State University and other college campuses throughout Northern California. Calculated to address significant issues impacting our nation, Professor Woods wrote the first of its kind training model, Policing in the Current Political and Social Climate, which he regularly presents to members of the San Jose Police Department and other agency personnel. He regularly participates with the Los Angeles County Sheriff Civilian Oversight Commission to build a bridge between the Los Angeles County Sheriff's Department and the communities it serves. Woods conducted training seminars through a foreign language interpreter to top Beijing police officials from the Ministry of Security of the People's Republic of China, emphasizing sources of legal authority, limitations to the use of force, and legal remedies in response to police misconduct. As an internationally respected legal trend and law enforcement expert, Professor Wood's analysis and commentary are regularly featured on television and radio, podcasts, and in print. He received his Doctor of Jurisprudence from San Francisco Law School and lives and works in the Bay Area.
The world is drastically changing. From Seattle to Louisville, Rochester to Los Angeles, Minneapolis to Galveston to Washington, D.C. Coast to coast, we are living through a stress test exposing flaws inherent to our justice system, and we look to the law to fix those flaws. With our time together today, we will examine contemporary legal trends, problems related to transactions between law enforcement and members of the community, and legislative solutions in response to those problems, impacting the rights and remedies of those community members and women and men of law enforcement. And as we conclude, I'll have some takeaway observations to share with you, the impact on practitioners and how it is that you might be able to apply this information that we share today. Because the information that we share today is crucial for our understanding of a trend that is enveloping our nation. If I may refer to Chief Carmen Best, former Chief of Police of the Seattle Police Department, I might add the first Black woman to ever hold that position in the history of that department, that sizable law enforcement agency on the West Coast, emblematic in many ways for the challenges, the obstruction, and the commitment to those law enforcement officers and their dedication to the proposition that the Constitution matters and how it is that they go about their business to control those forces, those elements that might very well compromise our expectations to public safety. Indeed, to promote public safety, it was the commitment of Chief Carmen Best of the Seattle Police Department who progressed through the ranks in Seattle, becoming chief after nearly 3 decades of dedication and service, assuming that responsibility to deliver public safety to the people of Seattle. But things changed, and as she observed on national television, on Face the Nation, Sunday, June 14th, 2020, where she said, Chief Carmen Best told the nation on Face the Nation, Sunday, June 14th, 2020, we are going to move in a different direction, and policing will never be the same as it was before. Oh, how right she was. How right Carmen Best was in her observation that we are going to move in a different direction, and policing will never be the same as it was before. Legislative bodies from cities and states throughout our nation have responded to these flaws, numerous as we will identify, connected with a single narrative thread, questioning the legitimacy of our system through which we dispense justice in the United States. One of the things that we will continue to come back to as we identify those problems is that they all emanate from a single source, a lack of trust. One singular problem that we might be able to identify from all that our nation is enduring, from Seattle to Washington, D.C., where there was an attack on our nation's capital, after which the chief of the D.C. Capitol Police resigned. He was invited to resign. Perhaps it was because there was no trust between those members of the community, as is exemplified, maybe captured virally on the internet and the instrumentality through the technological advancement that we now have at our disposal to identify those flaws within our justice system that illustrate a narrative thread, that confirm perhaps a transgenerational bias that is alive and well in many families throughout our nation, exemplified in Seattle, where Chief Carmen Best, too, resigned her position as chief, the first Black woman to hold that position in Seattle. After all, she said, she couldn't hold that position. She could not deliver what it is that she committed to provide in the form of safety and security to the people of Seattle with $1 million less in her budget, because it was the Seattle Police Department and it was the progressive minds of the city officials that alternated their interpretation of what it is that budget priorities mean, and to include not more police officers as a can-kicking maneuver, putting a Band-Aid on a transgenerational problem, where ultimately we might identify that problem as a lack of trust between those very institutions through which we call upon to deliver public safety, safety and security, with the face of that human being who wears the uniform, the badge, who has the training, the expertise, the knowledge to make decisions, hopefully consistent with the demands of the community, so that when the most hyper dramatic of circumstances present themselves to law enforcement officers in the field, and they are called upon to then respond to those most dire of circumstances that we have delegated to law enforcement officers and have trained them to respond with threat assessments, so that they might, well, at least federally, enjoy some sort of immunity, qualified immunity, in response to those decisions that they make under the color of law. Now, as we will examine, at least for the last few years, we have enjoyed an advancement of technological ability to conduct our own surveillance, to capture and record and make most viral on the platform of the moment. The most hyperdramatic will most certainly confirm that transgenerational narrative thread that might very well be critical of law enforcement and how it is that they respond to those problems. It is because of these high-profile events that are made viral that confirm perhaps a bias or a notion that the interests of law enforcement are not necessarily consistent with the interests of the individual members of the community. We might look to the legal scholar from Stanford, Herbert Packer, who in the 1960s identified a crime control model and held that crime control model separate and distinct from a due process model through which we might approach government, and the tension and the friction that exists between our government's interest to control crime, to respond to crime, to identify problems as meaning solutions in the form of public safety by hiring more police officers, and how hiring more police officers and training police officers to respond to these most hyper-dramatic of circumstances, now held to the scrutiny of the general public in greater numbers than ever before due to the advancement of the technology in the form of the cell phone and the platform of the moment that might illustrate the lack of trust between law enforcement and members of the community, and continue to erode the trust that may have once existed, but now might not have as much of a chance to remedy any kind of restoration where that trust might exist. We must examine the mechanics of trust and perhaps reverse engineer trust to determine how it is that we might attain it. And we look to the law. If we look to the law, we might be able to have transparency. Through the law, we might be able to have accountability. And it is only from the delivery of transparency, disclosure, and accountability that we will ultimately have trust. And so, how do we have trust in a system where we might examine increased rates of crime, as much as 30%, referred to as historically unprecedented, between the years 2019 and 2020, in many areas of the nation, as much as 30% of an increase in violent interpersonal crime committed by individuals with guns, domestic violence, self-abuse, suicide, overdoses, these things through which we encounter and might have as an indicator through these accountings of the worst kind of human behavior. And we look to law enforcement, we look to the justice system, we look to those practitioners throughout the justice system, the ancillary services, and all of those individuals that provide those essential services to those members of the community that ultimately will have the delivery of greater public safety. And in so doing, they will have trust in the system, legitimacy in the system, that they will receive what it is that the social contract, giving of your life, liberty, and property in exchange for the reasonable expectation that you will receive greater safety and security, security for yourself personally, security for your property, in that order. And how is it that if we play by the rules, if we relate to the common requests, and if we respond, and if we comply to what it is that a law enforcement officer might reasonably request in the field when responding pursuant to the threat assessment as to how it is that they should best address a problem? Now, recorded by so many with the ability to do so in the palms of their hand, equally leveling the playing field is the compulsion for body cameras. Now, many, if not most, law enforcement agencies, if not now, soon will be equipped with the technology to have all of their law enforcement officers conduct their own form of surveillance and have their actions be scrutinized, much like the Monday morning quarterback. And the impact of the social media and the platform that social media provides, we might be able to examine how it is that crime rates are increasing. And the hyperviolence of the moment might very well be compared and contrasted with, well, the trajectory that might have been set in place years ago. Maybe the legislative solutions that we have inherited have failed to respond to these transgenerational problems that only seem to be exacerbated, exemplified January 6th, 2021, in the attack on the United States Capitol. So how do we restore trust? Well, we have to follow the law, and we have to have faith and trust that the law is indeed legitimate, and that those individuals who are enforcing the law are equally legitimate, and they're enforcing the law for all the right reasons. The constitutional imperative, not unlike the categorical imperative that we might remember is delivered through the writings and life's work of Immanuel Kant, where we engage in a righteous path to achieve a righteous goal. And we look to the law to square the deal, to level the playing field, to act consistently with the constitutional demand for accountability, transparency. Only then will we get trust in our representative form of democracy, which is experiencing so much civil unrest, as we will examine from Seattle to Portland to Los Angeles, throughout our nation. We look to those legislative solutions that are imposed upon those problems that we might identify, particularly as they relate to the use of force and the access to information regarding the misdeeds, the misconduct, indeed the character of these individuals who assume the high responsibility, the constitutional mandate to enforce the Constitution, to enforce the law consistently with the constitutional imperative, to deliver safety and security. And those individual members of the community, they have a responsibility to comply with those reasonable requests of law enforcement officers, which will be easier to do if there is faith, if there is trust in that system, shown through transparency, accountability. Only with transparency and accountability will we have trust in these times of high crime rates increasing, unprecedented in modern history, civil unrest. Not in our lives have we experienced the incidents of civil unrest. From Memorial Day to Inauguration Day, chiefs resigning, throwing in the towel, whole command staffs walking away from their positions, a rudderless institution if we consider the musical chairs that is played by individuals who assume the multiple stars on their collar, leadership positions, many times promoted from within, resigning in record numbers. These people who have been around, who have absorbed these kinds of conflict. We might not be able to learn from their mistakes now that they are riding into the sunset. Such high numbers. How is it that we fulfill our requirements for recruitment and demand, particularly with a profession that might very well be in the process of losing its legitimacy, unless, of course, we change the law? As we will examine, the law is changing. And in those very areas of the West Coast, from Seattle to Portland to Los Angeles, well, we can examine the Attorney General of California, who has announced a pattern or practice report on the oldest sheriff's department in California, the largest sheriff's department in the nation, the sheriff's department of the County of Los Angeles, being investigated for the multiple allegations of the excessive use of force, more force than is necessary to eliminate the problem. In the threat assessment, the law enforcement officers, in a millisecond, based on a totality of circumstances, are trained to identify a problem and eliminate it in an efficient way. And when their life is at risk, when the life, the safety and the security of others is at risk, that law enforcement officer, well, has the obligation to use a level of force to eliminate that problem. However, when that law enforcement officer uses that level of force, as we will examine, as has been recorded and made viral, oftentimes it is the way that the law enforcement officer has indeed solved the problem by the use of force that has resulted with the undue scrutiny that has placed not only that law enforcement officer, but the agency that that officer represents, indeed the entire institution, at odds with the demands of the community that might find repugnant, perhaps liked and shared in the worst way possible on that internet platform of the moment. So how is it that we might increase the access to justice? How is it that we might have purpose of the justice system? How is it that we might define better and respect that duty of law enforcement by appreciating the social contract and the relationship that exists between law enforcement and members of the community? Safety and security in exchange for compliance with the law. Follow the law, receive safety and security. Reduced safety and security increases desperation. Desperate people behave desperately. We must go back. We must leave the social media platform of the moment and perhaps transcend time and space and examine the BART platform at the Fruitvale station, Bay Area Rapid Transit, the train that links the communities of the Bay Area, that is policed in a trans-jurisdictional way by the BART Police Agency, the BART Police Department. And it is one Johannes Messerly whose decision to draw a weapon from the duty belt that he argued in court in response to the allegation that he murdered Oscar Grant that New Year's Eve, 2009, so many years ago, captured and made viral on the BART platform, made viral on the internet platform. It was Google in 2009 that had already acquired YouTube. It was Apple that already had the generation of the iPhone already in the palm of the hands of so many, a technology that was not available decades earlier when Rodney King received treatment from the Los Angeles Police Department, whose defense attorneys argued that those officers of the Los Angeles Police Department were trained not to lose street fights. And so we square that, we cross-reference that in our mind with perhaps the memory of Rodney King, captured by the video camera, the top technology of the moment, captured secretly by an individual who saw the beatdown. It was made viral in its time by being on the news broadcast that evening, igniting unrest in many cities, including Los Angeles, where we can go back another generation to Watts, and we can think about the application of force by a member of the California Highway Patrol on a member of, well, the Watts community, a mother, interested in the safety and security of her son, who was being arrested by the members of the California Highway Patrol following a field sobriety test. One Lee Minkus could tell the tale of what occurred in Watts and what enveloped with those individuals who were killed and those buildings that were burned, not unlike what happened following the viral nature of the videotape capturing the beatdown of Rodney King, who received millions of dollars from the county of Los Angeles. After all, it is the county of Los Angeles that is now the subject of the pattern of practice report announced by the California Attorney General. A trend in the law, scrutinizing the behavior of those very law enforcement agents, not necessarily in a can-kicking maneuver, but identifying problems that have been with us for a very long time. We might go back to the 1940s, read a poem by one Langston Hughes, From Beaumont to Detroit. Let things drift until the riots come. And we ask ourselves, why is there civil unrest? Could it be that we have strayed away from the constitutional imperative? Could it be that we no longer have faith that law enforcement will deliver safety and security? Perhaps it is the roaming mobs of Portland. We might recall it is the U.S. Marshals that killed the shooter, that killed that supporter of law enforcement. We know that the person who was lying with the bullet in his chest in Portland supported law enforcement. I mean, he had the patch that had the blue stripe because blue lives matter. Though factually correct, misses the point in response to the death of Trayvon Martin and Oscar Grant. Trayvon Martin was not killed by a member of law enforcement, though we might think that George Zimmerman wanted to be a member of law enforcement real bad in the worst way. This community member, armed with a weapon, patrolling the neighborhood, and that kid with the hoodie fit the profile. And the jurors in Florida agreed with him. Stand your ground. We look to the law to level the playing field, to deliver safety and security. And when that law enforcement, even though the 9/11 operator consulted Mr. Zimmerman to walk away from the young Trayvon, it is because of the acquittal of Mr. Zimmerman that we have the Black Lives Matter movement, perhaps vindicated in the most recent flavor from Ben and Jerry's ice cream. The label emblazoned with the face of Colin Kaepernick, who seems to have achieved a sense of vindication in the past few years as we examine the trajectory of the law and how it is that we might respond to the crime rates and the civil unrest and the chiefs resigning and the onset of the technology so that we might be able to follow the constitutional imperative and deliver equal protection under the law, substantive due process of life, liberty, and property, procedural due process of one notice and a hearing. And in so doing, we might be able to achieve institutional legitimacy, what is in fact being questioned at this very moment, this social contract being breached. After all, what is the worst case scenario? It's an existential threat demonstrated by the attack on the DC Capitol building, January 6th, 2021. So why is there no trust in an inherently flawed system? Perhaps the law doesn't work. Maybe it's because we have accepted settlements instead of solutions. Maybe it is due to the untethered proliferation of social media. Perhaps there's something to be said about unequal treatment, notions of transgenerational oppression, the use of force by police, not to mention officer-involved shootings or killings, statistics that we haven't been paying attention to, but for the death of Mike Brown and the death of Eric Garner in the summer of 2014. The outcry led to many of us to begin to track these numbers, where we see a trend, where there is more killing by law enforcement in those more heavily populated areas of our nation. In fact, it is California, followed by Texas, followed by Florida. We can look to these statistics to try to determine where it is that this is occurring, but unquestionably, it's occurring everywhere. Is it not unreasonable for pockets of our population to continually receive the confirmation that they have received unequal treatment and that their notions of transgenerational oppression have been confirmed by the police use of force, the officer-involved shootings, the killings, in the transaction between those members of the law enforcement community and those other members of the community? Those men and women that wear the uniform, who patrol, who share the very sidewalk, the very street of those individuals that they are called upon to solve those problems in the most dire of circumstances. And whether or not that law enforcement officer might very well be perceived as judge, jury, and executioner right there on the sidewalk. How do we increase inclusion? How do we have the access to justice perfected with this constitutional imperative? We might consult the case of Donald Neely, Galveston, Texas, He was arrested in August of 2019. 2 police officers on horseback arrested Neely and escorted him using a rope. This image was caught on camera by so many who were sitting in cars in traffic as they watched the perp walk as they perceived it. Consistent with the policy that was trained since the 19th century, resembling a slave patrol, abducting a person that fit the profile of a fugitive slave. If we consider the trajectory of our history, these legislative solutions and the Fugitive Slave Act, then we might look to the way that these individual members of the Galveston Police Department decided to solve the problem. Mr. Neely was reported to be engaged in criminal trespass. Mr. Neely had a history with the Galveston Police Department. And so they handcuffed him and tethered him. And they escorted him on a nice day in Galveston, Texas, for all to see. And it is because of the humiliation. In fact, it is Donald Neely who now claims that he was in fear that he would have been dragged to death by one of those police horses. Nevertheless, Mr. Neely seeks $1 million from the Galveston Police Department, who were doing their job as they were trained to. After the image of Mr. Neely was made viral, within 24 hours on the platform Facebook, it was Chief of Police of Galveston who released in the form of a press release, because social media passes for traditional media in the age where the only way that the law enforcement agency might combat the viral nature captured, confirming perhaps transgenerational notions of bias, that policy was changed after over a century of training law enforcement officers who are mounted in the city of Galveston to escort those individuals handcuffed from horseback. They changed it overnight because it led to an outcry, evidencing the biased behavior. That behavior that is inconsistent, perhaps, as Mr. Neely demands in his suit seeking recovery in the form of $1 million for the outrageous behavior that these law enforcement officers were trained to do. As we consider the challenges that impact Texas, we might consider Fort Worth and the case of Atatiana Jefferson, who in October of 2019 was shot and killed in her home by a police officer. Fort Worth officer Aaron Dean was fired and charged with her murder. Jefferson's family files lawsuit against former police officer responsible for her death, was the headline in the local police Gazette. And that suit argues the city of Fort Worth and the Fort Worth Police Department are responsible for the former officer's conduct, systematically failed to provide adequate training and supervision for its officers. It is the suit by the decedent's family that questions the legitimacy of the way that these law enforcement officers are being trained, evidenced by former Fort Worth officer Aaron Dean's decision to fire his gun through Atatiana Jefferson's living room window. And we might consider the death of Atatiana Jefferson as reminiscent of the death of Breonna Taylor in Louisville, Kentucky, March 2020. Breonna Taylor fatally shot by police officers serving a search warrant. The city of Louisville agreed to pay Taylor's family $12 million and promised to reform police practices as part of a settlement. A settlement for a solution, or the promise to change the training, the policy in regard to how it is that law enforcement officers might conduct themselves, might respond to those problems that might present themselves in the way that they might assess those problems, particularly as being deserving of the use of force, perhaps mistaking that use of force, as was the case in March of 2018 of Oscar Grant. It is the death of Oscar Grant, who was using the cell phone to try to gain entry into his grandmother's house, where the flash of the cell phone was mistaken for the muzzle flash of a firearm. And it was not one police officer, but multiple police officers, perhaps sympathetically firing at what the one police officer from Sacramento concluded to be a problem, deserving of a response in the form of bullets, 7 of which were found in the back of Oscar Grant, leading to something that seems to occur all too often, and that is that not only are we receiving the resignation of the command staff and chiefs throughout our nation, but we are also seeing individuals taking to the streets and creating problems where they otherwise wouldn't be, where buildings are now attacked and individuals are injured, as was the case following the death of Stephon Clark, where a woman was literally rolled over by a member of the sheriff's department. And we think about the death of Daniel Prude in Rochester, New York in March of 2020. He died of asphyxiation after police officers took him into custody. 7 Rochester police officers in total are seen, captured on cell phone, captured on the body camera. We can see Daniel Prude wearing the spit hood. From what we understand, he was high on narcotics. He suffered from mental illness. If we consider how it is that law enforcement officers are trained and what we require law enforcement officers to understand as they respond to these most hyper-dramatic of circumstances, like that night in March of 2020, when the snow is falling, as is captured by the body camera, as we see the naked Daniel Prude on the pavement of the street, hands cuffed behind him, wearing the spit hood. Those 7 police officers have been suspended. The Prude family seeks a jury trial. The Prude family seeks unspecified damages. The complaint accuses 3 Rochester Police Department officers of using excessive force by restraining Prude, who was naked on the ground, hands cuffed behind him, wearing a spit hood. And perhaps if we might understand what it is that those law enforcement officers were responding to, those multiple police officers who were responding to the call to solve the problem. And they did so with the spit hood, as they were trained to do. It is following this event that was made viral, when made viral, that led to the resignation at the invitation of the mayor of Chief LaRon Singletary, promoted from within, departing along with the command staff in Rochester, New York. And we consider a whole history of reform-minded legislation that has been attempted in Rochester. And we can compare and contrast it with those problems that we have evidenced not only in Rochester, but on Memorial Day, May 2020, George Floyd, Minneapolis, Minnesota, died after being handcuffed and pinned to the ground by a police officer's knee. I can't breathe, man. I can't breathe. Hashtag the meme. Not unlike what was reported to be said by Eric Garner in Staten Island, New York, summer of 2014. The family of Eric Garner received $38 million in a settlement. The officer was ultimately terminated 5 years later for using the chokehold that the police department concluded they no longer trained officers in the academy. It was an illegal chokehold that was deployed against Mr. Garner, which led him to not be able to breathe, which became the hashtag, as was the hashtag of the summer of 2014 following the death of Mike Brown in Ferguson, Missouri. Hands up. Don't shoot. Following the death of Mike Brown in the summer of 2014, a pattern or practice report by the Department of Justice was conducted. Eric Holder, the Attorney General, introduced the conclusions of the investigation, that pattern or practice investigation of the Ferguson Police Department following the death of Mike Brown in the summer of 2014, where he concluded that based upon their investigation, hands up, don't shoot never happened. And Darren Wilson, well, who made the decision consistently with his training to use that level of force that ended with the death of Mike Brown, did not violate the law in doing so. In fact, it was reasonable, as we will see, based on the constitutional standard that has been with us since 1989. That standard that in the name of Oscar Grant is being questioned. And we consider that standard now more than ever following the death of George Floyd. Minneapolis police officer Derek Chauvin has been charged with third-degree murder and manslaughter. The other officers standing around, some new to the job, others looking to Officer Chauvin as a field training officer in the way that he was responding to the problem that day. Captured on cell phone, made viral, as we see those other officers who are now charged with aiding and abetting in second-degree murder, aiding and abetting in second-degree manslaughter. The family of Mr. Floyd has filed civil suit against the city of Minneapolis and the 4 former police officers. Excessive use of unjustified, excessive, illegal, and deadly force. With the living is Jacob Blake from Kenosha, Wisconsin. August 2020, left paralyzed after a police officer shot him 7 times in the back during a domestic dispute. No charges are filed against the Kenosha police. However, the district attorney reports that Officer Rustin Sheshki, who reported that he felt like he was about to be stabbed, was justified in his use of deadly force by shooting Jacob Blake in the back. Captured and made viral by members of the child's birthday party who were attending, members of the community who might very well be experiencing those transgenerational presumptions of bias, evidenced by not only the actions of Officer Sheshki that day, but upon further investigation, there have been 5 previous internal investigations of Officer Rustin Sheshki, the officer who shot Jacob Blake. As we consider the background of these individuals, these police officers who have made decisions in the field in the era of the cell phone, the era of the ability to have recordation of those decisions that are made in the field, whether they be on the BART platform in 2009 or whether they be recently in Kenosha, Wisconsin, memorializing the shooting by uniformed police officers of one black man in Jacob Blake, who now lives paralyzed. And those practitioners, those attorneys who are called upon to level the playing field, like Ben Crump, the attorney who represents Blake. He said that this case does nothing to help this issue of mistrust. Ben Crump, the attorney who represents so many impacted in this way, so many individuals, so many families. It is the attorneys who are called upon, like Ben Crump, who says that we have to have transparency and accountability to get that trust. Sounds familiar? In order to pursue the interests of the Blake family, it is the interests of the attorneys, as is the decision by Mr. Crump, to pursue a civil rights excessive use of force claim by way of the Title 42 of the United States Code, Section 1983, in a civil rights lawsuit against the Kenosha Police Department. It is Title 42 of the United States Code, Section 1983, that has been routinely and historically referred to and relied upon as a civil action for deprivation of rights under the color of state law since the Civil Rights Act of 1871, the era of Reconstruction. For Section 1983 to apply, the defendant must have acted under the color of any state, statute, ordinance, regulation, custom, or usage, or in the District of Columbia. Courts have determined that the under the color of clause requires that the wrongdoer qualify, at least in some sense, as a representative of the state when depriving the victim of rights. So how is it that we will have trust restored? Well, we must hold those individuals, those agents of the government, particularly when they impact our expectations to justice as they relate to our personal or property interests. We must hold them accountable, as is the legislative intent of Title 42 of the United States Code, Section 1983, accountability. But the problems that we're facing now, the problems that we have just merely skimmed the surface trying to examine by identifying those high-profile incidents where the law enforcement officer has been called upon to use a level of force that is repugnant to the majority of those individuals who are subjected to the viral nature from the platform of the moment. So how is it that we're going to have trust? How is it that we might enforce this standard to behave under the color of law in a way that is consistent with the constitutional demand, so that we might reduce that tension that exists between the civil rights model identified by Herbert Packer at Stanford University in the 1960s, how that commitment to combat and prevent crime might very well be at odds with our expectations to equal protection and due process under the law, where no two groups of people shall be treated dissimilarly. Well, the solution is to change the law. And as we will examine, it is through these legislative solutions that we will achieve accountability. It's the Supreme Court that ruled on how to assess whether a police officer has used excessive force. We look at the 1989 case from the Rehnquist Court of Graham versus Connor. Objective reasonableness depends upon the totality of circumstances, and how this objective reasonableness, where a reasonable law enforcement officer, based on a totality of the circumstances, will rely upon their training and their knowledge, their understanding of all that is going on at that particular moment, to use that level of force that might very well be required, that is necessary, well, or reasonable. Necessary or reasonable. That's the distinction. Because in California, in the name of Oscar Grant, that distinction is now being articulated with Assembly Bill 392. Since 2019, in response to the death specifically of Oscar Grant, but understanding that California leads the nation in officer-involved killings, where that use of force by the law enforcement officer, pursuant to that Graham versus Connor standard that we have inherited since 1989, so long as that law enforcement officer is acting under the color of law, what is it that we must combat when we respond to problems by calling law enforcement officers who have been delegated this responsibility through their training and their understanding? Must they apply a reasonableness standard, objective reasonableness, or might we ask those law enforcement officers now to cloud their decision making by perhaps including alternatives to the use of deadly force in the form of de-escalation techniques, crisis intervention techniques that we must now compel those law enforcement agencies to pay so that their law enforcement officers might very well receive the best training. And so that means that those law enforcement officers who receive the best training, so that they might use all of the tools in the toolbox to respond to a particular problem, by understanding those symptoms that might be consistent with mental illness. We might look to the legislature, as was the case in Seattle, as was the reason cited by Chief Carmen Best to abandon her post, to walk away from her historically realized position as the leader of the Seattle Police Department. How is it that she might deliver those outstanding police services to members of the community with $1 million less reallocated in the era of defund, the defund movement, defunding those very institutions that we hope to receive the best service from? We are defunding. The trend is to take away. It is not incumbent upon those law enforcement officers necessarily to receive the training that they might not necessarily demonstrate worthiness for. So these budgets have been reallocated to hire more social workers, more people who are skilled with mental illness, who have an expertise to respond to the needs of those individuals who are perhaps at their most desperate. And rather than responding like a hammer to a nail, it is the mandate of these legislative bodies throughout our nation to now take some of the responsibility from these individual human beings who historically have acted under the color of law, and to now assimilate perhaps within the ranks those individuals who are called upon specifically to deal with the needs of those individuals who are suffering from mental illness, substance abuse, the chronically unhoused, those individuals who have perhaps a second-tier existence when it comes to the access to justice. And so when we ask those law enforcement agents to go into those situations We have to determine whether or not we might use that 1989 standard of objective reasonableness pursuant to the case from the Rehnquist court, Graham versus Connor, or whether or not the jurisdiction will soon change that standard, as has been the case in California pursuant to Assembly Bill 392, where that standard, where the use of deadly force that is going to be used by law enforcement officers, it must be necessary to do so. It must be necessary to defend against an imminent threat of death or serious bodily injury to the officer or to another person. This standard is hopefully calculated to achieve accountability. Accountability in our attempt to restore trust between law enforcement and the justice system and those members of the community. In this era where those very institutions are being subjected to pattern or practice reports, as is the case in California, as was the case in Ferguson, Missouri, as we see the many lawsuits that are being brought by those individuals from the community who have, during those transactions between members of the law enforcement community, received something less than what is guaranteed pursuant to this constitutional imperative, this social contract. Their life, their liberty, their property has been impaired. Their civil rights have been impaired. Their rights to equal protection and due process have been impaired because of the decisions of law enforcement officers that now must be reasonable, as opposed to the California standard that increases that level through which a law enforcement officer might be scrutinized when they use deadly force. In this legislative solution in the form of the Assembly Bill 392, which alters that standard to necessary from reasonable. And we can already see in the way that officer-involved shootings is being reported by many agencies throughout the state of California, throughout many jurisdictions in the United States, is that not only has there been the information made available by that agency that there was an officer involved in a shooting, an officer-involved shooting that had occurred, but there will be more information that is routinely made available to the general public, usually through a press release, usually through a press conference by a member representing that agency, oftentimes the chief, where there will be additional information, where historically there wouldn't be because, well, it would be pursuant to an ongoing investigation where much information would be held confidential until that investigation concludes. But now, because it must be necessary in California for law enforcement officers to use that level of force that results in the death of an individual in the name of Oscar Grant, pursuant to Assembly Bill 392, as we consider Stephon Clark and his death at the hands of Sacramento police officers in March of 2018, where we would conclude that those law enforcement officers who are using the reasonableness standard reasonably concluded that the flash of the cell phone might very well have been the muzzle fire from a firearm, making it reasonable to conclude that their lives were in danger, making the Assembly of California pursue the legislative solution in the form of Assembly Bill 392, thinking about that trajectory that was set long ago through the community of Watts, through the community of Los Angeles, through the BART platform of Oscar Grant, to the backyard of Stephon Clark's grandmother, where we now realize that legislative solution in the form of the change to how it is that we now require law enforcement officers to only use that level of force when it is necessary to do so. Deadly force only when it is necessary. And because of that, we're hearing additional information when we learn of officer-involved shootings, essential information that includes why those law enforcement officers responded as they did. More often than not, we hear information that we otherwise wouldn't, that might paint the character of these individuals who have been killed by law enforcement prior to the conclusion of the investigation, that might very well cloud the character of that individual who is no longer with the living as a bad person, as a person of bad character who otherwise would be deserving of this level of force, because it is necessary, as is now the standard in California, as will unquestionably, through the trend and the trajectory set forth so long ago, be the subject of litigation. And those family members who suffer the loss of those individuals that they care most about at the hands of a law enforcement officer who might very well apply a different level of a standard of processing and assessing those threats, and whether or not that law enforcement officer used de-escalation or crisis intervention techniques or alternatives to the use of the fatal force that must now be necessary. It is that law enforcement officer who will be scrutinized. Because not only is it the actions of the law enforcement officer who might very well be captured and demonstrated most virally on the social media platform of the moment, that might then trigger those transgenerational biases that we learned so long ago and seem to be confirmed with the worst behavior exhibited under the most emotionally charged circumstances that we only see from the position of the Monday morning quarterback. Shared and liked. Historically, the information about those police officers was confidential. However, if we look to the Senate of California, we might consider the transparency and disclosure component to the reverse engineering of our notion of restoration of trust. If we must hold those officers accountable for their behavior, well, we must be able to identify their behavior. And as was the case in Kenosha, Wisconsin, as was the case with Johannes Meserly on the BART platform in 2009, it is these officers who have had histories of excessive force, who have had complaints filed against them. And had these complaints been known to the general public, perhaps it would have led to an outcry for greater discipline of these individuals. And perhaps those individuals wouldn't have been there to make the decisions that they made consistent with the pattern or practice of the way that they have made decisions in the past to apply those levels of force that otherwise might not necessarily be reasonable, nor necessary, as we consider the legislative solution in Senate Bill 1421 from California. Since 2018, peace officers in California now stand to have their personal records released. Officer personnel records, records relating to specified incidents, complaints, and investigations. These are going to be made available to public inspection. The Penal Code of California, Section 832.7, which generally made all peace officer personnel records and information confidential and exempt from this kind of disclosure. Well, that's changing. The trend in the law is that we now have greater access to the misdeeds, the complaints, the excessive force allegations of these officers. Indeed, we must look to the events that took place January 6th, 2021, the attack on the US Capitol. There are members of the law enforcement community who took selfies of themselves, posing with the individuals who gained entry into the Capitol building. There's an 18-year veteran from the Houston Police Department who was asked to resign. He was investigated by members of the FBI who asked him whether or not he was in Washington, D.C., and he ultimately said yes, that he was. On that day, January 6th, he said that he was in Washington, D.C. Well, what were you doing in Washington, D.C.? He said he was on business. So then they lifted up his cell phone and they showed the deleted photo of him at the rally with the former president. He then admitted, yeah, I was at that rally. Well, were you involved in the riot that led to the Capitol building? The FBI asked the 18-year veteran from the Houston Police Department, who said, I wasn't involved in a riot, no. Again, the cell phone came out and that deleted photo from that social media platform, that selfie of the officer in plain clothes, walking with those highly visible members with the politically charged T-shirts and flags, full-throated unison in the way that they were chanting. The officer was marching with them, actively participating in what we might identify as a riot. And then the question, were you in the Capitol building? The officer said, I was not in the Capitol building. Yet they presented the deleted photo, the selfie of himself. I believe it was with the statue of Gerald Ford, smiling, thumb up. The officer admitted that he went into the Capitol building because he wanted to see the art. Every arrest that law enforcement officer has been involved with over his 18-year career is now being scrutinized. Those individuals who have assessed to have been in violation of the law pursuant to notions of probable cause, each and every one of those cases, the legitimacy of the adjudication of those cases is being scrutinized because of the presence of this individual police officer at the DC riots, the attack on the Capitol building, January 6th. And this officer isn't alone. Every agency is examining whether or not they had members of their rank and file present in DC that day. And if they were, their mere presence implicates perhaps a biased interpretation of reality that is becoming growingly unwelcome within the ranks of law enforcement. Trust. Through the legislative solutions of Assembly Bill 392 and the police use of force, Senate Bill 1421, police officer release of records, force only when necessary, mental health, crisis intervention training, all in the rise of the defund movement, we might consider that Carmen Best might have left at our worst, that maybe she was correct in her presumption that policing will never be the same again, as it is changing in Minneapolis, and it is changing in Seattle. It is changing in Texas. It's changing in California. We are emphasizing those legislative solutions from California so that we might better understand how these problems will be responded to in jurisdictions throughout our nation. In San Jose, California, through a voter initiative, Measure G was passed, giving greater authority to the independent police auditor. The independent police auditor, a creature of civilian oversight, this model of having civilian community oversight over law enforcement agencies. The Office of the Independent Police Auditor in San Jose began following that Rodney King incident in Los Angeles in 1992 and was given greater authority. The Office of the Independent Police Auditor was given greater authority pursuant to the voter initiative of Measure G in San Jose, California, where it is the independent police auditor who will conduct an investigation of those law enforcement officers in regard to complaints of misconduct, of the use of excessive force. So we might be able to restore trust by having this investigation being conducted by an entity outside of the law enforcement agency that could deliver transparency to those government officials that might then report to the public how it is that we might be able to identify and respond to that conduct that we find questionable, the conduct that has been made viral, the conduct that is now the subject of so much legislation and litigation throughout our nation. So, how is it that we might be able to have the restoration of trust by involving these community-based solutions, responding to community demand, by embracing traditional notions of community policing, policing with policies consistent with the demands of the community, by involving community, by including into the equation civilian oversight. It is better to have the civilian oversight up front as a constant, as a component to the way that we might achieve transparency and accountability so that we ultimately might receive trust. It is better to have civilian oversight up front than to have a pattern or practice report conducted by the Attorney General or the Civil Rights Division of the Department of Justice. It is through civilian oversight that these agencies will be able to have full transparency and accountability in response to the conduct that we find unacceptable. And if we shift authority from institutions to community stakeholders, we might be able to embrace community policing principles and achieve transparency and disclosure and accountability in the process. And so we have to move with policing and our access to justice forward from where we are. And the only way forward is through a commitment to solutions consistent with community demand. Only then will we have a chance to receive the constitutional imperative to due process and equal protection, increasing the access to justice while preserving and restoring the legitimacy in those institutions that we rely most upon, through the restoration of trust, by following the law and understanding that trajectory and the trends of the law that impact us, and those practitioners who are sworn to uphold and defend those propositions that we have inherited from the Constitution as officers of the court. You might include or encounter those individuals who might be seeking solutions from the justice system in your own personal capacity. And so some takeaway observations, the way that this information might impact practitioners in a significant way, is by understanding that the scrutiny that is being visited upon the law enforcement community is severe. And as we consider the observations of Herbert Packer from Stanford University in the 1960s, as we consider the friction that exists between our expectations to due process and equal protection, and how we have to square them, or we will be subjected to the tension that is so live and well evidenced by the increased crime rates and civil unrest and departing chiefs and command staffs of law enforcement agencies throughout our nation. We have a tenuous expectation to justice and security based on the expectations that might have been inherited from around the breakfast table, where we might share stories of how members of the family were mistreated by those individuals who were abusing their power in the worst way possible. And we might consider whether or not we have crossed paths with one of these law enforcement officers whose misconduct has been scrutinized pursuant to the ability to access their records, or whether or not a law enforcement officer might very well seek assistance in response to a wrongful termination claim due to the presumption that what one officer may have done off duty might very well not be subjected to the discipline and the severity that might be visited upon that particular individual. The rights and remedies of individual members of the community, as well as the women and men of law enforcement, can very well receive guidance from you, the practitioner, in response to the information that we have shared today. Following the death of Mike Brown in Ferguson, Missouri, in the summer of 2014, there was a pattern or practice report that was published by the Department of Justice, introduced by Eric Holder, after which our president called upon the best and brightest minds of law enforcement to come together to identify those problems that impact us most. And on May 19th, 2015, the President's Task Force on 21st Century Policing reported that trust between law enforcement agencies and the people they protect and serve is essential in a democracy. It is a key to the stability of our communities, the integrity of our criminal justice system, and the safe and effective delivery of policing services. It is through the restoration of trust. We follow the law because we trust that the law will deliver us to justice. And I hope that the information that we've shared today will help you to bring yourself and those people that are within your network closer to justice. On behalf of the Center for Continuing Education, I'm Greg Woods.